Alrighty. Hello, everybody. I'm Christy, and I am the Executive Director with SSA. Welcome to our April Unclaimed Property webinar. Thank you for joining us today. We're going to hear from Jen Borden from Borden Consulting Group and Brian McCarthy from Sovos. Feel free to go ahead and use the question and answer feature for any questions you have throughout the presentation. We'll be answering them as they come in. So with that, I will let Jen and Brian take over.
Thanks, Christy. So I'm Jen Borden. I've been working in unclaimed property since 1994. I have an unclaimed property, a law firm specializing in unclaimed property matters, really focusing most on securities issues in Boston. And I'm delighted to work with the SSA on a number of issues. I'm very grateful that they convene us to go over these issues that we have, and then also for their advocacy in this area. And also very happy to be able to work with people like Brian on a lot of these audits and compliance issues.
And I'm Brian McCarthy. I've been in unclaimed property since 2005. I was a former holder, so I've sat in most of this audience's shoes, having to comply with laws. And, I've been with Sovos for 9 years. 11 of my 20 years in unclaimed property was as a holder. I thank the SSA for this opportunity to present with Jen Borden, and I think we should get started.
So one of the first things we wanted to talk about maybe already has changed since we put it on the agenda. But we wanted to talk about the law change in Delaware, where last year there was a very minor change apparently in the statute, that instead of talking about Delaware will take property that has a Delaware address, no address, or a foreign address, Delaware tweaked the language a little bit to say something along the lines of they would not take property if the address was in a foreign jurisdiction that had a custodial statute or something along those lines. But it seemed innocuous. Really, in my mind, the emphasis was along the lines of they were defining what a jurisdiction was. It didn't seem very apparent what they were attempting to do. Coincidentally, in that same legislation, they also pulled back some of the indemnification provisions in the statute, which will become a little more apparent why that's a concern as we talk in a minute. But again, focusing on the jurisdictional issue, didn't think that much of it. Fast forward to the beginning of this year, and Delaware representative just happened to say, oh, by the way, that change means that I'm only taking unclaimed property with a foreign address if it's in a country that does not have the exact same type of unclaimed property statute that we have here in Delaware. So the logical question back was, well, which jurisdictions is that? And the answer was, it's up to you to figure it out. So the securities world got together, asked Delaware, what do you mean by that? We were seeing, and Brian can talk about this much more than I, we were seeing that the unclaimed property auditors were using different countries than the unclaimed property VDA administrators were. And we were being left to our own devices to figure out what is this list of countries that maybe Delaware thinks this is applicable. Several groups sent Delaware questions asking for further guidance, pointing out all of the confusion. And Delaware basically said, I don't believe you. I don't believe this is really an issue. Prove it. And unless you prove, and we said back, the fact that you are asking us to tell you what your vendors are doing in the audit space or in the VDA space goes to show you that we need guidance from the state of Sheeter. And the response back to that was, again, prove it. Tell me which vendor said what, on what date, to what issuer. Then and only then will I give you any guidance. And if you don't give me that specificity, then I'm assuming that this isn't really an issue and I'm considering the matter closed. We being the groups that were involved, did not respond back to that last claim. However, and I think Brian has more on this, at the UPPO conference last month, Delaware indicated that there's a chance that that legislation may be pulled back because they did not really anticipate the confusion it would be causing. And did I get that all right, Brian?
Yeah, that's one of the last things that Brenda had said in her presentation was that they're considering rolling it back. That wasn't before she said read the letter of the law as it reads. It's plain and simple, pretty clear. But obviously, it's not clear enough if there's enough industry groups that are pushing back on it. On the audit side, there certain auditors were, specific to the holder that they were auditing for, were providing, oh, we're going to remove these records because it applies to this new law, and then other audits they're saying prove it. So there wasn't a consistent approach being applied, and I don't think Delaware was aware, is aware of that, and it becomes an issue. And then the burden comes back to the holder, and it becomes an argument. You're arguing back and forth. Here's the law, here's the link. Prove it. They're saying it's not, and then it's a big battle.
And not to spend too much time on just one state and the foreign issue,
Yeah.
but the reason why this is so important is that most of the litigation that we see where issuers are being sued, where transfer agents are being sued, it is a foreign shareholder who has suffered loss because their shares have been turned over, whether it's to Delaware or a different state. The shares have been liquidated and there has been a loss in value. So getting this right is imperative. And we did do a sort of an informal survey. And what we learned was that what holders were doing, and keep in mind, a lot of the compliance comes via the transfer agent world. So what we heard was a lot of, well, thanks for bringing the issue to our attention. We'll keep things business as usual, because it's too late in the cycle for us to change anything. So we'll keep things business as usual, but we are going to get together over the next year, and we will have this figured out by by the reporting cycle for 2026. Now that may change if the Delaware statute gets repealed, but that was option number one. Option number two we were seeing was transfer agents who brought the matter to their client's attention, to the issuer's attention, and said, hey, this is an issue. What do you want us to do with your foreign shareholders? And then there was an opportunity manually to pull back foreign accounts. And then the third option that some transfer agents took was to say, well, we don't know what this means. And because you have trimmed the indemnification provisions, we're not going to report any foreign to you until you tell us what countries this new law applies to. So we really saw a mix of all three. I'm happy to say that the SSA, in conjunction with the STA, has gotten together a little bit of a task force to try to figure things out. So we will hopefully have a meeting soon. And if you're interested in participating in that, let Christy know. Brian and I sit on the committee, so we'll happily get together to get some of those issues addressed, or get the best practices out there, or maybe to better articulate what the concerns are. So anything else on Delaware, Brian, or should we jump into?
No, I think that's it.
Okay, so sticking with that and keeping with this indemnification issue, what we saw a lot in the last legislative cycle was many states that are moving to reduce the indemnification that they're providing. So what they're saying is that indemnification, it used to be when in doubt, a sheet, because that was the way to avoid interest, avoid penalties, no harm, no foul. Unfortunately, due to the fact that the states are liquidating so promptly and so frequently, whereas they used to hang on to things, hold on to securities, we're seeing that is a problem. Additionally, what we're seeing is that the indemnification is being trimmed back to say that the only thing that you are indemnified for is a filing that is made in good faith, and only to the value of what the state got when they liquidated. Of course, that is a meaningless indemnification, because the only thing the damages would be if there's been an increase in value post liquidation. That's the piece that you need the indemnification for. You don't need the indemnification. If I gave you 100 shares at $100, you don't need the indemnification for that value. You need the indemnification for when the shares go up over $100. So that is problematic. And also, to harp on that, the Delaware foreign issue again, how do I say I'm cheating in good faith if I'm trying and I can't get, or how could they not say I'm cheating in good faith if I'm saying, I don't understand this, please help me with compliance, and then the state turns around and will not give further guidance? And by the way, this isn't the only issue that the states don't give guidance on. So keeping an eye on those statutes, I think, is really key, those statutory changes. knowing it's a trend. The reason it's a trend is because there has been so much litigation on the shareholder front with shareholders who have been harmed because of these prompt liquidations. We're also seeing the states in their statutes saying that they should be liquidating promptly. We're seeing they should be liquidating upon receipt. So those are things that are just complete sea changes from as recently as 2016, when the Uniform Law Commission got together and said we shouldn't have any liquidations for at least 3 years. And if you liquidate within 6 years after receipt of the shares, then we should be making the owner whole. That is not what the states are doing right now. And that is why I think this is probably a good segue into the audit section, but that is why it is so important not to listen and accept exactly what the auditors tell you, or even what the states tell you, because what you're doing is they are giving you guidance that suits them, and it may not be in your best interest. However, they only get paid if they get a significant amount of escheatment, or actually any escheatment. They get zero if there is no escheatment. So obviously they think that everything is escheatable, even if maybe there's another statute that would exempt the property in a different country. They'll just disregard that. They'll disregard that. And then the final thing that we're seeing is the states trending towards an inactivity standard instead of the traditional return by post office standard. Now, I can understand why they have done that. The contingent fee auditors have done a really good job of convincing the states that they should not use the RPO standard any longer, because not many people get things through US mail any longer, or the US post office isn't reliable post-COVID, or maybe post everybody getting fired there, who knows. They were also seeing that there's an abundance of securities being held in brokerage accounts, so you don't have outstanding dividend checks. When we do have outstanding dividend checks, when we do have dividends being issued, a lot of times it's via ACH. A lot of shares are held in dividend reinvestment plans. So there are less items to be put into the mail. People getting their tax returns and other notifications via email by choice, which makes sense. And all of these things that are done for our convenience, taking advantage of technology, those are the things that the auditors have convinced the states mean that we've forgotten all about our shares. So we should just assume that if we haven't had owner-generated activity within 3 years, we should be escheating that property. And so that is probably the best segue over to Brian and what's going on with audits.
Thanks, Jen. So I'm just going to touch on a couple audit firms that apply to this industry. I mean, there's many other audit firms, but there's a couple of them that really hone in on this industry as of late. I'll start off with EECS. They use the death master file and other databases to identify owners, potential owners or shareholders that are deceased. They use it broadly. So what that means is, we're seeing some states that are adopting law that has death as a trigger, and other states that don't have anything in their law that says death is a trigger. So, it's important to challenge the auditors and do the research, as depending on the audit states that are participating in any of your audits. Pushback. I continue to do this with every audit that comes across that uses this as a means for pulling accounts into the audit population. They, as Jen mentioned earlier, they're focusing on accounts with e-delivery only, asking for specific data requests that have those accounts that are flagged for e-delivery only. When was the last time you mailed something? The very detailed records request. That's where they're using the inactivity standard, because they're saying that you're never going to get an RPO if they have if they're receiving their mail electronically. Most companies have a bounce back process where if there's an email that bounced back, then there's it automatically defaults and it triggers to physical mail, which that would be the answer, right? There will be RPO if and when that happens. That's pretty much it for EECS. But I mean, detailed records. If anybody on this call's experienced an audit with Oliver, he he throws a hissy fit if he doesn't get his way, but definitely challenge him, and don't take for what he's asking for, for face value.
And Brian, before you leave Oliver, and really meshing with what I said before about get written guidance from the states of what they're demanding. Brian and I have an audit where Oliver is demanding withholding on IRA accounts, even though we don't have sufficient cash to do the withholding. So he's telling us to liquidate shares in the account for us to liquidate the shares before remitting to the state. And we told him we can't. And Oliver said he would get us guidance from the states. And this, to my knowledge, the states have not provided that written guidance yet, correct?
The states didn't want to get involved with that because it's really not an unclaimed property issue.
Right.
So
again,
Oliver was testing for it, which it's not an unclaimed. It has no, yes, you have to do it as a result of this treatment, but if the holder has no cash and they don't want to liquidate the shares, that's their decision.
Right. So that's why we keep stressing, make sure you get it in writing, because even sometimes when the auditor tells you, or if the auditor gives it to you in writing, it's much better if it's the state of New York giving it to you in writing, or the state of Florida giving it to you in writing.
Well, and that's a good example because that audit that we share, one of the states, he didn't give us to us in writing. The account in question in that phase of the audit, he deferred to the later on in the audit. And now we're back to dealing with, getting something in writing. So moving on to Calmar, we're seeing audits in Florida, Oregon, and Nevada at the transfer agent level, where Calmar is issuing the audit notices to the transfer agent directly, with kind of a Schedule A of the issuers that they want to audit on behalf of. Largely what I've seen in my experience so far is that they're existing audits where those states weren't in the multi-state audit, but now because Florida, Oregon, and Nevada have inactivity and death provisions, they're coming in and auditing these states for that. Oregon and Nevada would have the first time that you would have reported for the new law change would have been for fall, and Florida is just coming up, in a couple of days. So they're coming up. And speaking of Oliver, I have a Florida audit with Oliver, and he does the pre-submission requests. We, where that, they'll look at your report, ask you to hold back past due property based on the state's authorization in the notice. That client that I'm representing, we told Oliver, we don't believe that you should hold this back because this is new law, and he didn't hold it back. What he's going to do with it at the state level, because he started to ask for other things that had nothing to do with an unclaimed property audit that no other audit asked for. Once we pushed back, he walked away from it. So I think he was trying to get paid on it in a different way, because usually they remove the items and then you do a separate like audit submission. That's how they get paid. So definitely challenge and look at when the law was effective too, because all of that matters.
Well, and this is not legal advice. Certainly consult with your own
Right.
your own counsel, but the reason that they tell you to hold it back, that Brian just alluded to, is that the auditors only get paid for reporting overdue property. They do not get paid for reporting on-time property, nor should they. So in that Oregon example, if the fall report in Oregon was the first time that something was escheatable and it was due to the law change, that's on-time reporting. If Oregon wants to pay Oliver for it, they can do whatever they want. However, there should not be a delay in delivering it to the state. The state can go work out their accounting separately. Oliver can make his demand separately. But there is nothing in any state statute that says that you get to ignore your remittance obligations so that a third party can get paid or at a third party's instruction. And even if the state tells you to hold it back, I'm not sure they can. So as a best practice, what you might want to consider in that situation is, again, and drop a note to the state and say, hey, we don't see anything in the statute that authorizes us to hold this back. If you're telling us to, then we would request that you put in writing that we have a waiver of interest and penalties. However, we strongly object because we believe that that's only delaying reunification with the rightful owner, which is supposed to be the intent of the statute. Watch how quickly they take the property in and then deal with the auditor on their own.
Right. We touched on some of this earlier on in the Delaware discussion, but they're providing lists of countries that they're exempting based on the facts of the data in specific audits. The ones that I've seen were general ledger audits, and in others they're asking the holder to demonstrate it. So and pushing back if and when they do that. They're also, Kelmar recently with some contested population, they're accepting alternate methodologies to move away from inactivity standard. Where if you're able to demonstrate that the owner's at the address of record in a way, they'll take those off the table. So think of things that you have at your disposal that you can use to demonstrate outside databases from SEC searches, things like that, that'll tell the story of, confirming the owners at the address. There's no RPO in a state that has an RPO standard. There's no reason why they should remove, been successful in one state, we're going to try it in a couple of others, but again, it's important to, look at the data and think of ways to circumvent, the non-traditional tactics that they're using.
Well, and the funny thing was that one, I think you're referring to New Jersey, Brian.
Yeah.
So we had New Jersey take a look, and they removed hundreds of accounts because they could run, and I don't mean to signal Accurate, it's just like the brand name I know, but like Accurate or LexisNexis, and they could tell that those shareholders where we had a New Jersey address on our books and records also were reflected as getting their utility bills at that same address in New Jersey. And so they basically said that they in good faith couldn't keep them in their population. So I think that was a very reasonable approach for the state to take. It's what we were doing internally and advocating for anyway. So hopefully we'll have some more success with other states with that.
Yeah, it's nice to see the states go outside the box.
Mm-hmm.
That's pretty much it for the audits. I thought I'd touch a little bit more on Delaware based on the presentation that was done in UPPO, because some of the information that Brenda was able to share during that kind of was enlightening. I'm sure there's one or two people or maybe more on today's call that might have gotten that pesky Delaware verified report. Well, Brenda kind of outlined, where they're going with that, right? So, their current landscape, they have 1.8 million legal entities. She even admitted that it's probably over two. It's like closer to 2.2 now because of the timing of when they had to get that presentation done. 2/3 of that are Fortune 500. They're only getting 6,000 to 10,000 unclaimed property filers. So what they're doing is they're focusing the verified report process. When you think about it, they're focusing on the active, the people within their database, the companies within their database. There's that Schedule A, which is the second page where you can list the subsidiaries that roll up into the reporting entity. I think they're trying to chip away at that 1.8 million, as they go through their database, because she did mention that, once they get through all of it, they're going to focus on the non-filers, right? We automatically go, why are you picking on us? We're filing, but they're using the current filers to get to the non-filers because of the knowing that people do consolidated reporting and stuff like that. So I just thought that was enlightening because I've helped plenty of clients with Delaware Verified Report, and just her explanation made sense.
Well, in theory, Brian, it protects you. Like, so if you're reporting in a consolidated group and they can do a verified report and check off that you're down here, but you're coming in on this report, then this company down here is unlikely to get the non-filer audit report down the road.
Right. Right. They're taking those ones that they're not hearing from away, and then the delta will be the ones that they try to go after as non-filers.
By the way, we should mark the day I said something good about Delaware.
I gave credit where credit was due. She touched on fees, and I think this is important to some of the other things I want to talk about. The all of their exams, except for anything that has customer accounts, securities, or life insurance, the auditors are getting paid on an hourly basis. So normally, other auditors are getting paid in other states might be that whole contingency fee model. For Delaware, it's hourly. So where that's important, and specific to Calmar, is we've seen Calmar inflate the research population, right? Because then it takes them longer to go through that. They're getting paid to go back and forth with the holders, to review the records and challenge the support that's provided to remediate and all that. You know, we have one at Sovos where the overall this client's running a multi-state and a Delaware parallel, same audit firm. It was like 25,000 records, 14 were for Delaware, 14,000. That company hired full-time and like temporary employees to research those records, to get that down. But then now Calmar is backlogged, right? You know how they push everybody, you got to respond in 30 days. They basically said they can't get to it for like 8 months. So they put a 30-day notice on the holder to flip these files over. Obviously, we know we're going to request extensions and get that, but they're using that, right? That's the example with the hourly rate, right? So they're charging Delaware an hourly rate.
Can I push back on that a little bit though, Brian?
Yeah.
I have not seen a Calmar contract with Delaware that's a recent one, but the most recent one I looked at, and I've seen more than one, they said that it's an hourly rate not to exceed a certain percentage of the audit. And if their hourly rate did not get up to that ceiling of the whatever the 12% was, or 11%, whatever it was, then they got a credit that they could apply on other audits where the audit, if they went over that 12%, they got a credit that they could apply on the audits where the hours didn't eat up to that percentage. So it was almost like the worst of both worlds, because you could use a lot of research at one holder to justify getting a higher fee at another holder where a lot of research wasn't required. So she might have been a little, might not have given the full story.
Yeah, full picture.
That they're being paid hourly. And they are still getting paid contingency fee on the securities audits, correct?
Yeah, it's the securities, life insurance. That's what she mentioned. She kind of gave a statistic on exams, and I just thought it was interesting. 10% of the Delaware exams end after IDR 1 with 0 findings. I have experienced that. I've only experienced it once, and I was shocked. So, but it was interesting to see that there's a percentage of their audits that end that way. 15% of all Delaware exams ends with 0 findings after the remediation phase. So you get a population to research. Holders have good records. They're able to remediate that all. Where that's important, good records, save records. 50% of all Delaware audits are consistent, have findings consistent of actual property. So there's no estimation. And then the other 25% are where there's estimation. Just thought that, that whole breakdown, because we automatically think you're going into a GL audit, you're going to have estimation. It all depends on the records that you can produce and if they're researchable. Jenna, you want to take over at the SEC unclaimed property audits?
Sure. So I think we talked about this a little bit last year, but the SEC all of a sudden is really hot and bothered about 1780-17 audits. And we saw at least one company that had an audit where they sent out the 1780s, they had accounts that were coded as lost. They did the 1780-17 search, and the results came back with something that was off. It was either the name wasn't correct, for the social security number, or the name was like the first name was correct, but the last name wasn't. You could get the picture that there was no slam dunk, but this was definitely Brian McCarthy in New Jersey with this social security number. Something wasn't matching. And 1780D17 doesn't tell you what to do in that situation. And so this particular holder didn't do anything. They made a determination that it would be a fraud risk to send a letter to Brian McCarthy in New Jersey that the search results said that the account you searched for was Jen Borden's account in Massachusetts. So something was off. They decided not to send notification, excuse me, not to send the letter. Those accounts were eventually escheated. And SEC got all hot and bothered about that. They penalized the holder with a $500,000 penalty, and then they forced them to post certain notifications on their website and to give additional notifications to their clients. And they also forced them to help the owners go back and get the unclaimed property, the unclaimed shares back from the states that they had been escheated to. Now, there were, this was under the last administration, the two Republican appointees objected to this holding and said, there's nothing in the rule that says that this wasn't logical. This is regulation by enforcement. If you want to have these kind of requirements under 1780D17, then write them into the law. Don't try to do it by penalizing this one holder. Unfortunately, it was 3-2, so the $500,000 penalty went through. As a result, people should be scared to death about getting their 1780D17 right. The problem is when you consider the fact that a 1780D17 search only happens on an RPO account. Now you have all of these states that are looking to escheat based on inactivity. And so you might have an account that is, last time you mailed was getting mail at that address of record. 1780D17 is not implicated. Now the state switches to an inactivity standard based on a lack of activity. A US mail due diligence letter is sent out. That due diligence letter goes out the door. And if there's no response within 60 days, that account will be escheated to the state. Well, what if the due diligence letter comes back and that's coded as lost? Well, now you have to do your 1780D17 searches, but you don't have enough time to do that before you file your unclaimed property report to the state. So I'm very happy to say that the first state that came up with for one of my clients was Florida. We reached out to Florida and explained the situation, and Florida was wonderful. They said, nope, we can't tell you to avoid your federal requirements. So go ahead and do your searches. And if they're not successful, then put them on the next return. However, and this was the best part, warmed my heart, the number 2 person in Florida said, but we hope that they're successful and you don't have to escheat them. So good luck with that. So again, with the SSA and the STA combined are doing outreach to a bunch of states to say, hey, are you aware of this issue? As Brian mentioned earlier, Nevada is another one of the states that has recently moved to an inactivity standard. We just brought this to Nevada's attention, and early this morning, the deputy treasurer came back and said, thanks for bringing it to our attention. We will work on this with you. So if you're interested, this is one of those areas where the issuer and the transfer agent really should be working hand in hand to make sure that that outreach is being done and that there are no penalties for doing that. Of course, my druthers would be that we not have any inactivity standards, because then we won't have to keep having that push and pull with the federal requirements. But that's just me being practical. But on the SEC side, that $500,000 penalty, again, should be reason why you want to make sure that you're doing those searches, maybe getting additional outreach done. That shareholder outreach, that investor outreach, really, really important. I know the people who are on this call know the importance of outreach to the shareholders. So I know I'm preaching to the choir, but now you have this penalty hanging over your head as well that really wasn't there before. So the 1780D17 specific audits have definitely become a thing. I sit on SIFMA's Unclaimed Property Committee with Brian as well, and we've had a bunch of brokers tell us that they have been going through audits with the SEC. And then the more recent one I heard, which really shocked me, was that the SEC is also doing abandoned property audits. They are going into holders and asking for their abandoned property procedures, which on the security side are typically being handled by the transfer agent or the broker or a compliance vendor. And so all of a sudden, you know, and maybe this is because this group has been really screaming so much when we have our annual conference, when we meet with the SEC, but it really does seem like they are finally paying attention. But I'm not 100% sure that they're paying attention in a way that actually is helpful. It seems like they're on the punitive side and not necessarily on the how can we fix this side. Brian, were you commenting more on that?
No, I'm good.
Okay, so I just mentioned the case I was mentioning was the DST decision last year out of the SEC, but a couple of other cases that I just wanted to mention very, very quickly. BARF is a case in Pennsylvania, excuse me, in Delaware, where a shareholder's employee plan was turned over to the state. Even though she was still an active employee, we won't talk about how that happened. But bottom line is her shares were turned over to Delaware. They were immediately liquidated, no notice to her. She then looks at her employee account, her plan, the plan side shows how many shares she's been awarded. She knows that day's stock price, puts in her retirement papers and goes and kicks her heels up. Goes for the first time to liquidate some shares. And the broker tells her, what are you talking about? What shares? We issued those, you know, years ago. Go talk to Delaware. So from South Africa, she reaches out to Delaware only to find the shares have been liquidated. She got a very, in my mind, very modest sum. It was, yes, it was a couple $100,000, but at that moment in time, her account would have been valued well over $2 million. So she now does not have enough money to live on. She's retired. She tells me she has a hard time sleeping at night. She has filed her complaint at she filed her complaint with the Delaware Tax Appeal Board, which is the administrative requirement before you can get into Chancery Court. It was denied at the Tax Appeal Board. They basically said, well, this is what our statute says, so too bad, so sad. You get what you get, you don't get upset. So she is now, has sued in Chancery Court. Delaware's response was due on April 8th. They filed a motion to dismiss, but they did not explain their bases for their motion to dismiss. But their substantive response will be due on May 8th. So by the time the annual conference rolls around, we'll have more information on what Delaware's defense is on this. Very, very similar cases filed in both New Jersey and Delaware on behalf of another foreign shareholder. This one I'll focus more on actually in the Delaware case. Vile seeks to be a class action, which should scare the death out of any issuer to think that there's every shareholder that's ever been escheated is now going to be coming at them in a class action. So another reason why we make sure we're aware of what our escheat obligations are, that we're getting them accurate, that we're pushing back on the state or the auditor and how they're telling us to escheat, and that we're doing whatever owner outreach we can. The Vile case in New Jersey is a little more interesting because in that case, it's actually shares of Exxon, but they also sued Kelmar, who was the contingent fee auditor, who on an audit said that those shares should be escheated. And of course, there was then subsequent liquidation and shareholder loss. Very, very significant loss, by the way, in the case of the Vile family. They are beneficiaries who are claiming their, I think, father's assets. But there's some really interesting lines in that complaint where they say that Kelmar they should be defendants on this case because they only get paid if there's escheatment. They have an incentive to do their job poorly because them doing their job poorly is the only way they get paid. And you know what? No lies detected. So in any event, both of those cases, Barf and Vile, there was an administrative process that the shareholder had to go through before they could get into court. But that may now all be out the window, which, by the way, adds a lot of extra expense and time to the shareholder. But there's a new case that just was decided last week out of the 10th Circuit. So this is Colorado, the 10th Circuit Court of Appeals. And this is a case where it looks like it was cash, not shares. But it's still relevant to this group because there were two owners who looked and saw their name on Colorado's Unclaimed Property website. One of them was named, his last name is Nellinger. The other one's name is Story, spelled Storey. They went right into federal court. They didn't even make a claim to the state. They just went right into federal court and said, you took my property without just compensation. That is a violation of the Constitution. Please give me back my money. And by the way, this should be a class action and we should shut down Colorado's unclaimed property regime, at least the way that it is right now. There was a motion to dismiss. Colorado moved to dismiss, saying, we don't even know that you're the right Nellinger. We don't even know you're the right story. So you have no standing to make a claim. We don't think your claim would be successful. And so the claim was dismissed. They appealed, and the appeals court said, not so fast. There is no requirement to file a claim with the state to prove that you're Nellinger or your story. It's reasonable to think, based on your names, that this could be your property. So we're not going to dismiss so quickly. Number two, we don't even have to look at whether or not it was actually your property that was taken and it was done incorrectly or in bad faith, because the second that property is taken, that is a taking. If you weren't given just compensation, that is a taking. And there's no requirement to go through the claim process or even the administrative appeal process. So their claim is back. It is back and it is strong, and it is a very strong constitutional claim. And when the state complained about how difficult that meant, how difficult that was making it for them, what the court said is, under our Constitution, private property shall not be taken for public use without just compensation. Period. Hard stop. And then they further said, of course, if Colorado wishes to avoid defending against these suits for unclaimed property, it can always decide voluntarily to revise its laws or practices. So I am delighted that this case was just decided right before I have to do my response in that case in Delaware, because it kind of seems like the federal courts are really not too enamored with the whole way this unclaimed property regime is working. And so that is a good segue into advocacy. Again, very grateful that the SEC, I would say that the SSA has always been really looking out for its members' interests and for their shareholders' interests. We should have soon a decision in the case Warner v. Hillsborough County, where the SSA filed a very similar case to what I just described, where the SSA filed an amicus brief telling the 11th Circuit that the way that the unclaimed property regime was working was not appropriate and would result in takings of shares. Another initiative that we have going on right now, and maybe we'll do a little more of this at the annual meeting, we're continuously bringing to the SEC's attention where the unclaimed property statutes are stepping on their toes, like causing the avoidance of a 1780-17 search, and forcing a sheetment on property where the owner is still receiving mail at their address of record. We also are working with the state of New York. I just mentioned Brian and I talked to Florida. We're talking to Nevada. We also have New York saying that she will have a discussion. This would be joint with the SSA, the STA, and SIFMA. And I think ICI wants in on this as well. They represent mutual funds, to figure out what best practices are. So yes, we all acknowledge that less mail is going out, and maybe that might mean that we don't have a return mail standard. But what can we be doing short of a sheetment of everything? Like Brian was mentioning earlier, checking databases proactively, maybe doing some other type of outreach proactively. Any other things that you can think of quickly, Brian, that we might be talking about with New York when the time comes?
Well, there's that section in RUPA that has that electronic outreach after 2 years, like thinking of that, like how to stay engaged with your shareholders. I know from going to prior conferences, most of this group does something like that. But if you're not doing it, consider it. Trying to engage your shareholder earlier. That RUPA requirement also, alludes to, if you don't get a response within 30 days, mail something. So there's your RPO element if the address is bad. So there's ways to, kind of either have or don't have the RPO element, because you could say you mailed something and it didn't get returned either. So you can use it for both sides of the fence there.
I think, Brian, would it be accurate to say, I don't mean to speak for industry, but the groups that we sit with, there seems to be a collective thought that it will be, instead of saying, well, there's no RPO, so go away, it will be more productive to say, we understand that there are fewer pieces of mail going out the door. So this is what we're going to do instead to prevent escheatment. And if that fails, then maybe we should have a discussion. That sound like that's
Yeah,
something.
no, that seems where everybody's going because of what we're seeing in the audits, as I described earlier, right? Like
Mhm.
you have an auditor that's focusing specifically on electronic notifications.
And so one thing I want to add to that, so going back to that DST decision where the 1780-17 didn't have specific requirements, but yet they were being penalized. I think that's an opportunity for industry groups to come up with their best practices. And so if the feds or the states aren't individually going to say, this is exactly how you should do this to protect your investor or your shareholder, maybe we as a group should come up with that. And then let's say someone in the group chooses not to follow those best practices, well, then maybe they don't look as good as the issuer who is doing all of those outreach programs. So just something to think about. I know that that is definitely on the STA's agenda. I know Melissa McCarthy from SSA is also going to be working with us on that. I think there may be some others on this call who are looking at coming up with developing those. And again, I'm grateful that states like New York is also open to having that discussion. Do you want to talk a little bit about the death trigger at all, Brian?
Well, just from a best practices, right? We talk about the states that have the death provision. This group is already getting kind of knowledge of death through the SEC searches with your vendors. Turning that data into something useful for your companies, right? Or use it as a fraud prevention, right? Especially single named shareholder accounts, right? If Jen Borden's, if you have knowledge that Jen Borden's potentially is deceased, maybe you put a flag on their account, their account, so that way I can't call in to try to transact on it or something like that, or maybe I have all of Jen's identifying information, but if you know that she's deceased, then you know that I shouldn't be trying to access her account.
Well,
Um,
what, before you go on that, Brian, I just wanted to say, you just mentioned that we know this from the vendor who's doing the SEC searches, but what we found out is that the groups that are doing the SEC searches and getting the results that indicate that the shareholder is deceased, that information was not necessarily being turned over to any
right.
other group within the company. So please make sure that right hand and left hand know what's going on and you take advantage of the information that each has.
Yeah, that's a good point, Jen. Another use to that is if you know somebody's potentially deceased, sending out a notification to confirm it, right? Um, you know, you can tailor a notification in a way that kind of just gets somebody to respond, and then you can get the necessary paperwork if it's confirmed to transfer the ownership sooner, right? Wait instead of waiting. Um, and then obviously if you have knowledge of death and you have a place for it in the systems, it's going to help for those states like Oregon, Florida, and Nevada, and some others that have the death trigger as a trigger for dormancy.
And then I think that's all we wanted to cover. We wanted to leave some time for
Yeah,
questions. Did
definitely.
any questions come in, Christy?
Nope, I haven't seen anything yet. Does anybody have any questions they want to get to Jen and Brian?
Well, if there are no questions, I would say that definitely, if anyone is interested in working on those initiatives, either to come up with best practices for outreach or to how we can work with the states or work with the SEC, there's unfortunately a lot of that extra work usually falls on all the same usual suspects. So volunteers welcome, and I've never known someone to come to the table and not have a good idea. So really the more the merrier there. So anyone who's interested, please let Christy know so she can pass it along to the Legal and Regulatory Committee that Brian and I sit on.
We did just have one question come in. It says, should the contact date be updated for a deceased shareholder if a family makes contact?
I think so.
If family makes contact.
I think so because on death now the owner of the shares is not the deceased person. It is the person it's the estate, and then someone has to figure out who the estate is. Obviously, Kevin, this is if it's not a transfer on death. But if it's transfer on death, then obviously we have a new owner. But if the new owner is the estate, I think you update it. But I also, the only reason I caution that is what typically happens is you will find from the person is deceased, you'll send out the claim kit or the transfer kit. And then if it doesn't get returned to you and you just let that sit there 3 years later, when you turn it over, the auditors come in, the state comes in, they say, well, this person's been dead for X years. Why didn't you do anything? And you say, well, this person reached out. Bottom line is update it, but make sure you stay on top of it. And I know that that's not a really great answer, but like I'm trying to answer legally, but also practically.
Well, Jen, what about delaying it a cycle? I mean, but versus updating it, at least if it's a 3-year dormancy, you're giving it a year for that person that expressed interest in it to get the paperwork together.
Yeah, so what's interesting is on the insurance side of the house, in every unclaimed property statute, it says that if the person is deceased, then you have a certain amount of time to effectuate transfer to the beneficiary. I think that makes sense to do it on the security side as well. The states don't necessarily agree with me because they want to hurry up and get a sheetment.
Right.
But I was actually in the insurance session of an unclaimed property session, and the states were pushing for that. And a bunch of folks who work at insurance companies stood up and yelled at them, saying how they had beneficiaries calling in who would say, we are grieving. We simply are not in a place where we should be forced to do this quickly. And they really shut the states down with how, rushed they were trying to be about it. So I personally believe that that's a great answer. Again, maybe we add that to the best practices list. If we go to the table with the states and say, look, we're trying to do this to give people time to get things done. I will say that during COVID, I had an auditor, North Carolina, on an all-over audit, tell me that they were not going to wait to let the estate finish processing transfer to the beneficiaries. And the court was closed. The court was closed because of COVID. So they physically could not conduct their probate business, but the state said, too bad, escheat it anyway. And thankfully that holder said, no, we will not. Like we'll run the risk of a penalty because we have the owner right here. Someone in the chat just put about there was a DMF article recently about the file containing people who are not eligible for social security numbers. That is going to create the biggest cluster because what's happening now, the administration's move to strike all of these people who've been given social security numbers, or maybe they were using social security numbers of people who were once living US citizens. It goes to show that DMF is even more unreliable than it was before. I don't know how much it will necessarily impact the securities world, only because I think if we get a death hit on the DMF, I think we're being given the opportunity to confirm the death. And so I think there's the chance to go and like send out a claim kit, figure out if it's true and accurate. But it's definitely a first line of defense to say just because it's on the DMF doesn't mean it's Bible. And by the way, I also don't know how many shareholders that's impacting. That might not, like those might not be the people who are getting stock improperly from the list. Hopefully that answers the question.
All righty. I don't know if I see anything else. Does anybody else have any other questions for Jen or Brian? All righty. Well, thank you everybody for joining us. We're glad that you were here. If you do think of any other questions or anything you want to talk to Jen or Brian about, please feel free to email me and I will get you in touch with them. I also hope to see everybody at the annual conference in July. We will be in Denver, Colorado, and registration is live on the website now. Thank you for joining us and have a wonderful day.
Thanks for your time. Appreciate it.
Thank you guys.
Bye. Thank you.